And thank you for joining us today for our monthly plan webinar series. Our March edition is discussing the developments of regional impact. So happy St. Patrick's Day. I am Stephanie Verdial. I am a principal planner here at the Office of Planning and Development. And today with us, we have Susan Slack. She is a principal planner. With the principal planner with the Lakes Region Planning Commission. James Bordine is with us today to discuss a little bit about what he encounters with DRIs in our panel discussion. He's from the Stratford Regional Planning Commission. And Kayla Tavares, she is a principal planner from the North Country Council. And again, our featured speakers today. So thank you for participating and helping. Again, please turn off your cameras and your microphones. Going to go through a little webinar logistics here. So we are going to have a panel discussion towards the end of the webinar, but please feel free to use the chat and we will go through the chat questions as well through the panel discussion. And if you're not familiar with the how to use the chat, it's up above your screen on the right-hand side. You can see the open the chat box and raise your hand option as well. So having said that, please make sure again that your cameras are off, your microphones are off, and that if you are thinking of any questions, just put them in the chat and we will get to them through the question and answer period through the moderated panel. And so here we are today discussing the developments of regional impact, the best practices for board members. So I am going to go through and give a brief introduction of the RSA 36, in which the DRI laws are located, and just kind of a basic little introduction to it and when the law was enacted. Susan is then going to go through the overview of the law, a little bit more of the procedural things with the DRI and amendments. She's also going to talk about the DRI determination process and procedures for boards, and then a few case studies as far as experiences with she's had and what communities go through with the DRI process. Then Kayla is going to talk about the North Country Council's guidance document for DRIs. There's also going to be discussion with determining the thresholds of DRIs, how a board determines that when you actually have a DRI. Then she's going to go through some case studies as well, and then we're going to have a moderated panel discussion with some question and answer, and then just a final overview, wrap up, and a review of best practices. So the DRI, to understand the development of regional impact RSAs and why they're located, where they're located, you may think that they could be located in the planning and zoning regulations, chapter 674, but they're located in chapter 36, which is the RSAs that govern the regional planning commissions. And so the reason why that they are with the regional planning commissions is because part of the regional planning commission's charge is to prepare and develop a coordinated plan for the development of a region. So there are 9 planning commissions in the state. So those planning commissions are responsible to coordinate and develop regional plans for their regions. So they work with all the municipalities. They're aware of the municipalities, certain strengths, weaknesses. So they're in charge of taking care of their municipalities in their region. And so that's, the RPC's function and purpose, like I was saying, is that they are to work for and with those municipalities. And part of developing the regional plan is working towards developing transportation plans, developing regional housing needs plans, economic development, recreation plans. So again, the RPCs are in charge of their region and the long-term planning for their regions. And that's kind of how it flows into this development of regional impact, because so that's how they go into the development of regional impact, with the regional planning commissions being involved with the municipalities in their region for when there's those DRI developments. So now, the RPCs are involved with working for and with their municipalities. So the purpose of, in January of 1992, the legislature enacted RSA 3654 through 58. And, the main purpose of this section of the RSAs is to afford notification and input opportunities to the RPCs and to the neighboring municipalities regarding a development proposal, and specifically whether that development proposal will have an impact on those neighboring communities, excuse me. So that's why the DRI RSAs are in the same RSA chapter as with the regional planning commissions. You have to understand that connection as to why RPCs are involved, what their role is. That's why we're talking about that's why we're having this discussion. So to understand that what the legislature wanted to do was to foster and have this coordination of regional planning. And what I find, particularly interesting is, the third point of the purpose of the RPCs in the language out of the law, to encourage municipalities to consider the interests and potential impacts to neighboring municipalities. So again, by triggering and utilizing this law, you are coordinating and fostering cooperation with the RPCs, with neighboring municipalities. And most of the time, those neighboring municipalities are in the same RPC region. So again, the RPC has the municipality's best interest at heart, so to speak, because they are working on the long-term regional plan in the region where those municipalities are located. It's kind of the relation, kind of what RPCs are working for and with the municipalities of their region. And that's how part of this coordinated regional, municipal planning effort is obtained. It's accomplished, is that these long-term planning goals can be met and through this coordination of what's going on in one municipality. It only helps the municipalities, it only helps the RPCs. So that's the basic kind of introduction with the RPCs and DRIs. So I'm going to turn it over to Susan, and she's going to talk in more detail about the law and go through her program. So Susan, I'll turn it over to you. I'll advance slides here.
Okay, thanks, Stephanie. Good afternoon, everybody. So I'm not seeing the slides advance, or there we go. So what I'm going to do is just run through the statutes themselves and what is required by them. And the first question is, what is a development of regional impact? And RSA 36:55 defines that term. And it's any proposal before a local land use board that the board determines could reasonably be expected to impact a neighboring municipality because of certain factors, and we'll get into those as well. So the statute lists 6 factors, but it also says the DRI determination is not limited to those 6 factors. So there could be a development proposal that includes some other issues that the local land use board thinks will have some impact on neighboring municipalities. Okay, next slide. And those 6 factors are the relative size or number of dwelling units compared with an existing stock. So a large development in Nashua might be perceived differently than a large development in Hebron, New Hampshire, here in the Lakes region, which has a population of all of 632 people. Other factors are proximity to the borders of a neighboring community. So is the development site close to the town line? Transportation networks are a factor to consider. State highways as well as town roads that are potentially impacted by the development. Anticipated emissions, light, noise, smoke, odors, particles. Another one is proximity to aquifers or surface waters that transcend municipal boundaries. And finally, shared facilities such as schools or solid waste disposal facilities. So those are the factors that a board would consider when determining whether a proposal before it is a development of regional impact. So next slide. So when should we determine that there is a development of regional impact? The statute, RSA 36:56, says that the local land use board is required to review an application for its potential regional impact upon receipt of the application. So very early in the process, when a board, say planning board, gets a subdivision application, one of its first steps should be to look at it in terms of its regional impact possibilities. The statute requires that the board review the application promptly for regional impact and determine whether, if they approve the development, it reasonably could be construed as having regional impact. And so these are kind of discretionary decisions, and you may have some doubts sometimes. Is it a DRI or not? And the statute says that doubt shall be resolved in favor of a DRI finding. So next slide. Who determines? It's the local land use board that defines whether there's a development of regional impact. And the statute says local land use board is as it's defined in RSA 672:7. And that statute lists the planning board, the ZBA, the Historic District Commission, the building inspector, and if a town has a building code board of appeals, then that board also could receive an application that could be considered a development of regional impact. The statute also says, or other boards or commissions authorized by RSA 673 and established by the legislative body, which is kind of, I don't know if that's really necessary in the statute, because those other boards or commissions are the Heritage Commission, the Agricultural Commission, Housing Commission, and they are unlikely to be receiving development applications, although the local land use board might want to consult with them because they do have a lot of knowledge about the resources in the community. And also note, where we're talking kind of nitpicking about the statutes and how they're worded, that conservation commissions are not authorized in RSA 673, so they're not included in the DRI statute, but they are authorized in RSA 36A. So, the Conservation Commission also doesn't receive development applications that could be considered DRI. So that's kind of extraneous maybe wording in the statute, but that's neither here nor there. It's really the planning board, zoning board, Historic District Commission, building inspector, and building code board of appeals if you have one. Next slide. So again, we talked about when the determination should be made, and that's, upon receipt of the application and review it promptly. So I think we're going out of order here a little bit, but next slide. So I think a good practice pointer for these land use boards is, most of you have a checklist of the steps you take when you receive an application, a subdivision application, or even a special exception or variance at the zoning board. you usually have a checklist of what steps you take. And one of those steps at the very beginning should be a review of, is there a potential here for regional impact? So I think listing that in your rules of procedure or your application checklist is a good idea to remind you to take that review early on and then move on. Okay, next slide.
Hang on, they're warming up.
So once you've determined that there is a development of regional impact potential, what is the procedure that the board follows? And that's laid out in RSA 36:57. Basically, the board notifies the Regional Planning Commission and affected municipalities. So when you're discussing whether it's a DRI in the first place, you probably should have a discussion of which municipalities are affected. Is it just one neighboring town, the other side of the town line, or is it a group of surrounding towns? So give some thought to who the affected municipalities are. Then the statute requires that you provide notice to the Regional Planning Commission and those communities within 5 business days after you make the decision. And notice is by certified mail. And included in that mailing should be the minutes of the meeting where you have discussed whether to find that there is a development of regional impact, so that the RPC and the affected municipalities have some idea of what was discussed and what factors you thought led to your determination of regional impact. Next slide, I mean. Continuing with the procedure, you're giving the RPC and the affected municipalities the status of abutters, and that is basically the significance of finding that there is a regional impact. And, as Stephanie mentioned when discussing the purpose of this statute, the whole significance is just to notify the RPC and other towns that there is this potential and give them an opportunity to be heard. That's all there is to it. Timely notice, input, and for the local land use board to think about what the interests of other municipalities could be. Next slide. So over time, this statute has been amended. It was first took effect in 1992, and in 2003, the first amendment was kind of an important one, I think, and it added to the procedure that not only should you send the RPC the minutes of the meeting that you determined regional impact, but a set of plans so that the RPC has some idea of what's being proposed. And interestingly, this statute doesn't require that a set of plans be sent to neighboring municipalities, but that might be a good idea to do that as well. Other amendments are originally, once making the DRI decision, the local land use board had 72 hours to notify the RPC and neighboring towns. That was amended to 144 hours and then finally amended again to within 5 business days. So it gives you a little more time than originally you had, but still it's a quick procedure. Next slide. Other amendments, 2008 is when the building inspector was added as a quote unquote land use board that could find that a development has regional impact. So this says that when the building inspector receives a building permit application, and the use or a structure being proposed has the potential for regional impact, the building inspector then can make that determination as long as the planning board or zoning board or other board in town hasn't already considered a DRI. The building inspector then notifies the governing body in his or her own town and the RPC and affected municipalities. And then those entities are given 30 days to submit any comments before the building inspector can issue a building permit. So that was kind of a big amendment. And then finally, the only other amendment has been to allow regional planning commissions to develop guidelines to help their local land use boards in determining whether a development has regional impact. The Regional Planning Commission then is required to post and advertise notice that they are going to develop guidelines and allow for public participation in that process. And then those guidelines are adopted by the commissioners of the Regional Planning Commission. So those are the amendments that have taken place in this statute. Next slide. So that, that's the quick overview of the statute itself. Each of us, I think, is going to talk a little bit about some experiences we've had with developments of regional impact. One in our region that is ongoing currently is a gas station, convenience store, apartment site that's just west of the Maine border on the southern end of Ospey Lake. The Ospey River flows out of Ospey Lake east into Maine and provides drinking water for a number of Maine municipalities. The site is at the intersection of a state highway and a town road, about 300 feet from the town line. Most of the town road is in the other town. And the site sits above the Ospey Aquifer, which is New Hampshire's largest stratified drift aquifer. Next slide. This gas station, convenience store, and some other commercial uses on the site were developed before the town had a zoning ordinance. Then in 2011, some years after the town enacted a zoning ordinance, they added a groundwater protection ordinance that prohibited gas stations in that overlay zone. In 2015, the owner removed the underground storage tanks and the gas pumps and stopped operating the gas station, but continued with convenience store and food and apartments and laundromats. So it's still a commercial site. Then in 2019, all commercial operations ceased on the property. And in 2021, a new owner again proposed a gas station as well as the other commercial uses. Next slide. So the ZBA considered a variance request to allow the gas station in the groundwater protection zone where gas stations are prohibited. They decided that improved underground storage tanks with double lining and sensors qualified the applicant for a variance. That decision is on appeal to Superior Court, so that's pending. And the appeal was brought by some abutters, residential abutters, as well as a very active lake association and very active watershed conservation group. Next slide. So the ZBA did discuss this issue as to whether there was a potential for regional impact and decided there was not. And among the reasons for that decision, they said that finding that it was a regional impact potential was unlikely to affect their decision making, and that the size of the project didn't rise to the level that they thought was regional impact. Next slide. While all that was pending, the applicant submitted a site plan application to the planning board this year. The abutters and local organizations pressed the planning board to make a determination that there was a DRI, and the planning board did vote to do that, and notified the RPCs and the affected municipalities. So next slide. To wrap this up a little bit, some questions that were raised through this whole process. One, this is a small town that has only volunteer planning and zoning board members, no professional planning staff, and some very new members of both of those boards that probably didn't have deep knowledge of the DRI statutes. So one question is, the ZBA decided not to find regional impact, and yet the planning board did. And one question was, does one board's decision carry over to the other board? And, you know, I think the statute is pretty clear that the land use board that has an application before it can make the determination. So one board is not bound by the decision of another board. And the DRI determination, was that necessary? Some board members said there's been a lot of media coverage. Everybody knows about it. So why do we need to even determine its potential for regional impact? And I think the answer there is that because the statute does require the board to make a review and make a determination, and if there is regional impact, to notify neighboring towns. So that duty still resides with the board. And in this case, a number of Maine municipalities were notified, and the question was, do they have a butter status, and was the board required to notify them? And I think no, the board was probably not required to notify them, but chose to do so anyway. A butter is defined in the planning statutes as you know, a person in New Hampshire whose property adjoins or is across the street or stream from the potential site. So, you know, the requirement that abutters are in New Hampshire probably says that the town didn't have to notify the Maine municipalities, but they chose to do so. And I guess I don't think that is a problem. So those are some questions raised by that case study. It was a little complex and kind of a little messy at times. But our next one is working out a little bit better. This is a 60-unit condominium development. The site is directly across the street from the town line. The larger town is about 4,500 to 5,000 population. The other town is much smaller, 1,000 people or so. But all of the emergency services, post office, church, restaurants, shopping, a town beach, a boat launch are right across the street in that neighboring community, and are the ones through mutual aid. EMTs will arrive first, police will arrive first, fire, so on. So that raises issues of financial impact on the smaller town. There's some traffic and pedestrian safety issues, some environmental wetlands, stormwater issues. But next slide, the larger town where the development is proposed had ZBA and planning board approvals are required. The professional planning staff in that town recommended that DRI status should be given to this project. The smaller town was immediately notified, as well as the Regional Planning Commission. So that those public hearings are ongoing, and the smaller town is participating in all of those hearings and making their concerns known. How it comes out, we don't know yet, but at least there's a lot of discussion going on, and that is exactly the purpose of the statute. So those are two experiences we're undergoing here in the Lakes region. So thanks.
Fantastic.
We'll move on.
Yeah, thank you. Fantastic. Thank you very much, Susan. We do have a few questions in the chat, so we're going to hang on to those until we get to the panel question and answer part. So please, question pops into your head, just throw it into the chat, and we will get to it when we have our question and answer discussion. So having said that, we'll turn it over to Kayla now.
Awesome. So I'm going to take control here of the slides. All right. Bear with me all if I'm a little slow sometimes. My computer can lag a second, so giving it time to catch up with me.
Yes, it's this day and age.
Yeah, right. The technology is good, but we're still all working on it. So I wanted to take a little time to talk about sort of the guidelines that North Country Council developed. Susan sort of mentioned the statute amendments that gave us the authority to do so back in 2009, but off the tails of that, up in our region, North Country Council worked with our commissioners to develop and adopt a set of guidelines to help our communities ask specific questions, to help them sort of understand if they have a DRI and what the sort of impacts they might be looking at are. So on this slide, I kind of wanted to give you guys an idea of how those categories, when we did our guidelines, we broke them into categories. And so you'll see those across the top of the slide here. So we sort of come up with 6 areas where we say you should think about if a development application is in front of a land use board in your community, ask yourself the question, might it affect a neighboring community in one of the following bucket areas, right? And these bucket areas for us, we group as economic structure, infrastructure capacity, settlement patterns or regionally significant features to the area, natural resources, quality of life and emissions, and then we have a sort of a simple catch-all for projects that directly abut a municipal boundary. I think it's interesting to think about these in terms of and sort of comparatively to what is put forward very clearly in the DRI statute in the definition section that Susan introduced earlier. So along the bottom, the circles you'll see there have those 6 factors from the statute that Susan listed, reiterated again here. And as I go through the next few slides, what I'll do is dig a little bit into what questions we ask in each of these buckets and where we have sort of added a little bit more meat to the bones around some of these 6 factors in the statute and where we have sort of broadened it to catch other considerations in our region with what we've adopted up here. So, like I said, there is a lot of words on this slide, and I honestly did it so that you guys could sort of see the way we sort of phrase that all as questions to consider for municipalities when they're looking at these applications. So I broke things out here into a couple of sections. So our first 3 buckets were that economic structure, infrastructure capacity, settlement patterns, or regionally significant features. And so within each of those, we had a series of sort of specific things to think about to really sort of dig into that question of, do you have a DRI in front of you? And might it affect a neighboring community or a larger set of communities surrounding you in one of the following ways? I actually think this gets to one of the questions that was put in the chat by one of our attendees earlier about sort of trying to sort of figure out where those threshold points are. You'll notice when you look at the slides, some of these are blue. And the ones that are blue, I actually highlighted because they line up with those 6 factors in the state statute, so you can see where those fit for us and then where we've kind of widened that scope a little bit. So, you know, in our economic structure, we'll ask questions about how what you're doing might impact the cost of basic services in a surrounding community. So we look at like energy costs there, right? If something is going to cause energy or utility changes in a very significant way, that it might affect the cost of those in another place. That's something we sort of call out as a way you might be impacting a neighboring municipality. We have a handful of pieces in here. This is where we catch housing for a lot of points. And so, you know, that first option in the statute tells you number of dwelling units and location. We do a little bit more in our guidelines to sort of flush out what those numbers and distances might be in our region with our commissioners. So we talk about if you're constructing 50 or more within 1,000 feet of a boundary, these are sort of specific numbers to be looking at in those applications to see if you've got one for our communities and what we've agreed on up north. And then we also look at sort of what the impact of your non-residential or commercial industrial building is, depending on the scale of it and its location, right? So we have a smaller scale for some commercial activities that are closer to boundaries. And then we realize that there's some development that, regardless of where it is, might just be a large enough development. It impacts your neighbors, even if it's not close to those boundaries, right? So we sort of try and flush things out in that way. We do the same spirit of things in infrastructure capacity here, right? And here, the blue ones you'll see highlighted towards the top speak to that transportation networks concern for us. We talk about whether or not you're creating access points in another community, how many vehicle trips are getting created based on sort of the current MUTCD manuals. We draw a specific number in there, around 100. And we sort of look at ways that you might be impacting those highways or regional connectors and town roads with changes to their service and access, sort of who's getting to them, how many people, and how many people they're moving. We also look in here about solid waste, which is another piece that goes into that shared facilities from the definitions. We look at things that produce a lot or will require specific facilities to address, because sometimes those facilities fall outside of your community. And so if those do, it's good to see where they are, right? And then we look a little bit about demand for emergency response personnel and things of that flavor in this bucket area. We do the same thing, so settlement patterns and regionally significant features. This is where we catch some of that piece of how might it affect our historic and our cultural, our natural and our scenic features that are here today. And we also have an interesting one. One I think is very interesting in here for us is this middle one, which is about whether or not a development is located in an area that just has not supported that size and type of development before, right? So an interesting example of that is a lot of times in between up north in our smaller communities for certain, there's some pretty rural spaces in between our village centers and downtowns and communities. And sometimes when a new greenfield development is coming in, you might find that just because of the fact that that area has not been developed before, it's going to change some of the factors around what's going on and what's needed there. So these are some of the ways we do that. The next slide I'm going to switch to now. I'm going to sort of do the same thing with our last 3 to give you guys a flavor of what they look like here. So in natural resources, this is where we hit on those aquifers and our surface water pieces to sort of hone in on ways that you might be impacting a neighbor there. And what I think is nice about these guidelines overall is they help sort of flush out the picture, right, of what to be thinking about when you're looking at a development. We also look here about whether or not, one of the things I like is whether or not you're impacting natural municipalities. So you'll see that phrase incorporated into our guidelines where we say, you know, is this development having a notable ability to alter or destroy or degrade the natural municipalities and habitats of our animals and ecosystems, especially beyond your municipal boundary, right? Where are those areas? So we catch a lot of our environmental pieces. We try to flush that out here. And then our last one is that quality of life and emissions. So we talk here specifically about those particular emissions that come along, like light, noise, etc. But one thing we add in here that's sort of worth pointing out is in our region, we've specifically called out the visual impacts of cell towers and how they might impact other neighboring municipalities as an area for our communities to pay particular attention to. And then, as I said, that last one we have is we tend to keep this catch-all here for any development that's directly abutting a municipal boundary, even if it feels a little small, might have a regional impact because of its location. And so we catch those there. So that's a little bit about how we sort of came up with all of our guidelines and how they're used. What I want to talk about now a bit is how they're used. So we up here at the council, we use those guidelines as staff, but then we also use them for their intended purpose as a guidance document for the municipalities. So earlier, I kind of talked about how we use those with the municipalities, right? It's a document adopted by all of our commissioners back in 2010, and it is something that they all have access to use in their own decision making. But what's also interesting, I think, to note is that when we as a regional planning commission are notified and decide to submit comments, we use those same outline of our guidelines to frame the comments we give about potential impacts. So because of that, there's, I believe, sort of a nice reciprocal process that happens there where we ask the municipalities to ask particular questions about how it might impact their neighbors. And then we use that same framework to help them see how that might impact some things at a regional level. So we sort of use these guidelines as the basis of how we work through our DRIs, not just at the community level in determining, but also when we provide comments at the regional planning commission level. We take that combined with our regional plans and the goals, aspirations, and strategies in there and sort of see what that picture looks like in a wider network for those large developments. All right, I'm going to pause there and say now I have a couple of case studies to talk through. They're a little less in depth than Susan's, but I wanted to give you an idea of what this looks like in our region recently. I will say we've been seeing more and more DRI notifications, which is a really great thing to see. It means there's a lot more awareness and gives us a lot more space for that really good collaborative planning cross jurisdiction that does not get enough energy. And I think this is a good avenue for us to do it, right? This is a good way for us to work together. So the first example I want to talk about here is a cell tower that was proposed adjacent to the Franconia Notch Parkway. So this, as you'll sort of know from what I was saying a few slides ago, cell towers and their visual impact is something we have honed in on in our guidelines specifically. But this one had some interesting factors to it beyond just a cell tower application coming forward due to what it was decide. And so, you know, in this case, the application was directly adjacent to the scenic byway. I-93 through that section is a designated scenic byway in the state, and our Regional Planning Commission has a very active Scenic Byways Council that works on promoting and strengthening those areas. And so we sort of looked at it specifically to see how it impacted our understandings of our scenic byways and what that might mean for the region. It's also adjacent to, clearly, Franconia Notch State Parkway, a very important natural resource area for us, for ecological purposes, for habitat, and also for the strong tourism drive of the region. And that sort of brings me to the third thing about this example that was interesting is it brought about a lot of conversation about prominence from local view sheds and trailheads and historic features and basically natural features that are such a big draw in the parkway. So in this place, we did participate in the hearing process. So the community where this application was located notified surrounding communities in a pretty big distance. That was partly due to the state statute around cell tower development, but also because of our DRI guidelines. And most neighboring communities did not participate in the hearing. But as I said, because of its potential impact to the scenic byway, it was something that the Regional Planning Commission joined in on. And I want to sort of give you an idea of what I think were some of the value added in us coordinating that with the town and participating in that process. We worked with them to help the planning board figure out the best methods and sites to assess that visual impact. So we helped them figure out, I mean, they were going to ask for a balloon test anyway, but we helped them see where the balloon test should be observed from, right? Where are those places that it might be seen so that we can get documentation of that full picture and see how to mitigate it best. We were also able to help that community make sure that they put pieces in place for them to be able to legally maintain the vegetated buffer the applicant offered to keep in between the cell tower and the scenic byway. That was something that was sort of a value added from our knowledge of enforcement of those that the community wouldn't have grabbed on its own. We were able to make sure they were able to get easements from the applicant to maintain those and ensure that it stays buffered in the future. And then the last piece is we were able to have a pretty meaningful exchange with that community, with the developer, and with our regional knowledge around the broadband and communication needs of the region and what it means to balance that with against sort of visual impact. And so that was a very valuable sort of process for us, I believe also for the community and the developer. It certainly added more conversation, but it all sort of added conversation that helped move the project forward in a way that we helped mitigate some of that impact for them. A second example is a funny one I'm going to give you because it's one that lends with sort of a punchline of it may not have been a DRI, but that wasn't a problem, right? And this goes to that err in the side of determining when you can, right? So we recently were notified about a 2-lot commercial subdivision proposed in a community. The planning board had properly discussed it. They determined that it was a development of regional impact, and they went through their notification process accordingly. And when we received it, we looked at it at the Regional Planning Commission. We compared it to our knowledge of the area and said, okay, this is in an existing commercial area. It is centrally located in that municipality's commercial district. And there's no development proposed on the site at this time, except for the splitting of the 1 lot into the 2. And so we had a really nice exchange with our community in this sense to talk with them about how we would not be providing comments from a regional perspective at the point of that 2-lot subdivision, but that we may, as a subsequent site plan review or conditional use permit comes forward for a use on that site, that might sort of come with some of that more impact. And for us, that was really a discussion about tying our reviews to when the impact is there to be mitigated. And what was most beneficial, I think, in this exchange with us and our community is we were able to talk about how it's absolutely right for them to determine a DRI and lean in erring on the side of caution at every chance they can, but that we will sort of save our comments for the time that they seem most meaningful for the applications going forward. And so it was a great way for us to be aware of something that will be coming down the pike eventually and start a conversation with our planning boards about when we do and when we don't sort of weigh in on regional impact for us. So with that, I believe I'm going to flip us over to the panel discussion and say that's kind of the end of my piece.
Okay, fantastic. Thank you very much, Kayla. So we do have some questions in the chat. So what I think I will do is start with the questions in the chat first, and welcome James to partake here in the question and answer, and then we'll open up to the panel just to make sure that we're getting a little close to 1 o'clock, and just want to make sure that people that had put chat questions in, we'll get them answered. So let me scroll back in here into the chats here. So our first question is how do regional plans incorporate or collaborate with each town's master plan? So any one of our RPC experts want to jump into that one?
I think it would be great if they did. I think it's a case-by-case basis. And, you know, does the community reach out to the RPC to help them develop their master plan, and the RPC can bring to bear some of the broader issues in the regional plan? So I think sometimes it works well, sometimes it doesn't. I don't know if the other RPC representatives have other experiences.
I think Susan's got a very honest summary of that. I think I'll add it just and say that, you know, I think that there is a nice space for the two to inform each other when municipal planning boards or planners, depending on sort of who is in each municipality, reach out to the RPCs. We can, a lot of times we up here will tease out data or key points from some of our regional plans to help spur discussion in community master plan updates, even when we're not more hands-on involved in them. So I think there's space for it to be better, and it tends to be a little ad hoc right now.
I wasn't going to add anything. I think you both covered it pretty sufficiently.
Yeah, thank you. Thank you. Good question. Okay, so we're moving on here. And let's see, we may have discussed it a little bit in the slides, but just for a little bit more for clarity. Is there a list of common regional impacts that we should use as a guide? For example, shared water as a protected river.
I mean, I think I'll jump in here because I feel like I talked a bit about this in our guidelines.
Yeah.
But absolutely, right? And I think one thing to be aware of is reach out to your regional planning commission. There are people like James, Susan, and I who you probably know in your region too. And ask them about whether or not your commissioner has considered adopting commission-wide guidelines for the region, or if there are some that your planning board just wants to consider. But I mean, you saw sort of the depth and breadth of what we've put together up here, and I'd say certainly, as the statute says, you are not limited to looking at sort of what they list in those 6 factors. And if there are pieces in your community that are clear shared resources like that, I think it's absolutely right to look at them.
Yeah, I was just looking on my website. We do, SRPC also has guidelines, and then we also have a separate document that, you know, is interrelated, but it's essentially the review checklist that I run through when something gets referred to me. And on that, we have 8 categories with, you know, probably 5 to 10 guiding questions under each. That sort of look at, you know, do you impact municipal facilities in this way? Do you impact scenic and visual character in this way? So if you have something that's coming before you and you're wondering, is this regional impact? Definitely take a look at those. Feel free to reach out. I've also seen a few communities, Northwood, where I provide contract planning services, being one, that have adopted some of their own local sort of definitions of what that community's planning board considers to be a regional impact. So they've sort of set up some of those guidelines for themselves as part of that regulatory discussion process.
Yeah, good question. I would say that if you didn't have, you know, what's the basic kind of outlined in the RSA for transportation or housing, if you didn't have, you know, have those set aside as your guidelines in your site plan or your subdivision regulations, to definitely reach out to your planning commissions and other communities. I know that Pembroke has a pretty good set of DRI examples, and of course, you know, most of them, all the caveat at the bottom, or maybe the last one, and any development as the board sees fit. So they kind of have that catch-all. Well, it may not really fit into these types of categories, but if it's, you know, a different type of development, then the board has that description, even it has that ability to declare it a DRI, even if it's not explicitly listed. So it's a good question. Thank you. So next question, how large of a gas station would it take to raise the regional impact? in a protected watershed. And as a second half to that, can a neighboring town sue another town if they don't do a DRI on an obvious DRI?
Those are good questions. And, you know, the local land use board has a lot of discretion in deciding whether or not to determine that a proposal will possibly have regional impact. And what may be obvious to one person may not be obvious to another. I think the land use board needs to have a really good discussion about it. What are the factors they're looking at, and what leads them to believe there is a potential for impact or is not a potential for impact? And that's why the minutes of that meeting are to be shared with the RPC or the affected municipalities. As to whether can a board be sued, I think, I don't think, as I recall, that the New Hampshire Supreme Court has issued any decisions on developments of regional impact decision-making. But I think there have been some Superior Court cases where DRI has been an issue in a case. And I kind of recall, maybe it was Conway a number of years ago, where the Superior Court sent the case back to the local land use board to say, hey, at least take a look and decide if this is a development of regional impact. So can a land use board be sued? Anybody could be sued about anything. But I don't think there have been any Supreme Court decisions on it.
And Stephanie, if I can jump in real quick too,
Sure.
you know, I think one thing that I've had to deal with a lot, or I've gotten a lot of questions on, is the difference between regional impact under RSA 36 and applications at a municipal boundary under RSA 674-53. And so while not declaring regional impact, you know, may or may not grant a butter status, there are certain circumstances where the adjoining municipality is legally entitled to a butter status, or even potentially, you know, I think one example being the only way to or from the development is from that adjoining municipality. They might have the authority to review that application themselves directly as it relates to access. So, you know, while saying, hey, we don't feel this to be a regional impact, might cover your base under that RSA, for things that are close to or are on the boundary line, definitely take a look at some of those other legal ramifications. And then sort of the other way that I think about this and, you know, phrase this to people is when we're talking about regional impact, the benefit that you gain by being named as potentially impacted is a butter status. And so if you're thinking about, you know, the risks of what if we don't name this other community or any of that, you know, I would be thinking about it sort of in the same way as, well, is that other adjacent property really in a butter or aren't they? It's the same kind of question. And I think the ramifications are, you know, did they have the opportunity to know about the process? Did they have the opportunity to participate in the process? You know, that's essentially the consequences that you're trying to weigh if you don't declare something. And I think the clearer way that I was sort of taking away, Susan, what some of your comments were yeah, you are likely going to have bigger problems if you don't explicitly address regional impact than if you address it and decide not to declare it.
Yeah, I think that's right. Yeah.
Yeah, I would agree with that too. Yeah, good points. Okay, thank you. Good question. So we'll move along here to our next question. If a land use board fails to even address DRI on a new application, which does have regional impact, is that cause for a rehearing in which a DRI will be made prior to hearing the case?
I think we sort of touched on that.
Yeah,
I've
yeah.
gotten one that was sent to me where the ZBA had already heard and denied an application, and then they declared DRI on the request for rehearing that they were considering, and we did our best to provide comments that way. I think this is something that doesn't come up very often, so it's not uncommon for planning commissions to sort of make our processes work, even if the best case scenario is within 5 days of declaration or as soon as possible after taking in the application. We can work with you to try and get the best result possible under the circumstances that we're under, or help you to do the best job you can.
Yeah, thank you. Good question. Thanks, James. Okay, looks like one or two more here in the chat, so we'll get through them and then we'll move to the panel questions that we said we were going to discuss. So let me scroll down here. If the board deems a project a DRI, should they cease discussion until the surrounding communities and RPCs have been notified? And
Yeah, the statute doesn't really fill in a lot of the blanks, but I think that's a good process. In the gas station case, the planning board was under the misapprehension that they couldn't consider the DRI issue until they had determined that the site plan application was complete. And that took several meetings over the course of several months. I don't think that's a good process. The statute says a prompt decision upon receipt of an application. Then you determine the DRI, and if yes, you give the notifications so that the affected municipalities and RPC can participate. So yeah, I think it's a good idea to cease at that point and wait till the next month's meeting, if you will. I've also had the experience where an applicant, a developer, submitted the application with a request that the board find that there was regional impact right away and get those notices out. And I think that's pretty efficient. They figured that the issue might come up and they wanted to get it resolved right away and get the process rolling in a good direction. So I think that's a good approach.
yeah, one thing to kind of remember just basically and procedurally is that if an application comes before you with the potential for being a DRI, you, as a practice pointer, you should discuss that DRI process before you accept the application as complete. If you accept the application as complete, then you start the 65-day time clock review for the application. And if you declare a DRI, then you're adding 30 days or taking away 30 days. So that there's that little bit of that procedural order that if you should declare something a DRI, don't accept the application as complete yet. Continue to the DRI and follow that process and then go through the completion process.
Well, sort of on that note, I would push back a little bit on that. At least because one of the applications, and it was admittedly literally my first day on the job. The first thing that I worked on after my employment paperwork was, hey, we got this thing and you did site plan review in Ohio, so do this. And the application was not complete. Like it was very clear that the materials were sparse. It was an excavation permit, so half of the things that were required under RSA 155E weren't provided yet. You know, in my staff reports, when I'm staffing my planning board, I always have them paired at the top. But I do completeness first and then regional impact. And I've tried to train my board that first you make the motion on completeness, but then the next thing before anybody says another word is the discussion and motion on regional impact. I think to your point about notice and timelines and that sort of thing, it certainly does clean up the 65-day clock if you can declare regional impact before a decision on completeness. But I would sort of suggest that the application, it would help if the application could be found complete instead of was sort of missing a lot of stuff.
Yeah, we'll take the converse thing of that to make sure. There's nothing of course you can accept as complete and then declare a DRI. One more thing you have to keep track of is that extension request that you get from the applicant if they go past 65 days. 65 days is still kind of that weird time frame for them to make a decision. So for my administrative practices, it makes it a little bit cleaner and one less thing that staff or a planning board with no staff has to keep track of that 65-day time frame. So if you declare a DRI and then accept at the DRI, then you've prevented that loss of the 30 days without having to keep track of it. Kind of housekeeping stuff. It's a good practice to make sure that they are looking at the completeness for DRIs as well, though. So very good. Okay, thank you. Okay, so that did it for the chat. I don't see any other questions in the chat, so we'll move quickly to, I know we're kind of running over here, but I did want to get to the panel discussion. There's some good questions in there, and if everybody has to jump off, we understand that this presentation and the slides will be available on our website next week, so we're kind of aware of the time, but this was wonderful presentations, and we'll kind of go through our panel discussion here for those who are still hanging around with us, so I appreciate that. So panel discussion, first question, application, which we've spoken about a little bit, but we'll get some discussion going. Application needs approvals from the ZBA and planning board. Should both boards declare a DRI?
I don't, oh, go ahead, Caitlin.
Oh, so, Susan, I was going to say you can go ahead, but I'll start. So I was going to say, I think when we've talked about this before, each board has their own authority and capability as a land use board to do so. And so the zoning board and the planning board, they are looking at different things when they review a development, right? The point is not a duplicative review between the two. It's that some are considering for some factors and the other boards are considering for others. So I think they certainly can both declare a DRI, but to Susan's point in the Ossipee example, you don't have to follow the example of another board. You can disagree and make your own independent determinations. You don't need to declare both unless both boards would like to have neighboring municipalities involved as abutters in the RPC.
Yeah, and in the example of the 60-unit condominium development, where both boards were going to have to weigh in on aspects of the proposal, the planning staff had discussions with each board about DRI and encouraged them both to, find regional impact to get the other town involved in both sides of the process. So I think that worked out pretty well.
Yeah, I think under our guidelines, we at least generally think about this if, for example, something needs ZBA first and then planning board approval. In terms of our involvement in the process, we would usually try and identify issues that are likely to be relevant through that entire process. So if the ZBA declared it to us, we might also be thinking about and putting some comments on these things might come up as site plan. So we'd like our review and comments to sort of be relevant and part of the record for everything. But you know, I think that raises a good point that if the first board declares it, you are conferring a butter status on those proceedings. If the planning board has separate proceedings, presumably, you know, declaring regional impact again would be the only way to guarantee that those same municipalities are also abutters in the different application.
Yeah, and my familiarity with an application that came to the zoning board and the planning board, they declared a DRI at the zoning board level, and then coincidentally, you know, the meeting schedule was ZBA the night before the planning board meeting. So at this ZBA meeting, they declared to be development of regional impact. They had also applied for the planning board. It was noticed as consideration of a DRI and then the public hearing for the application, depending on how it turned out. So the ZBA declared a development of regional impact, and the next night at the planning board discussed it, and they, you know, at the public hearing, and thought they didn't feel the need to declare the site plan application in front of them as a DRI as it had been declared for the ZBA. So, you know, and again, that's kind of up to the board's thing. Both boards are looking at different things, whether it's a variance or a special exception in a site plan. But, you know, the planning board at that time, they took into consideration the time and the expense for the applicant as well. So, you know, and that's kind of where these, you know, the boards can work with applicants on their submission and on DRI, or the applicant is proactive, like Susan said, you know, please declare this a DRI. But, you know, it's good that the boards are communicating, and it's good that, you know, that's how the process is supposed to work, with cooperation and notification. And just in that particular instance, the planning board thought it was a little bit too much on the applicant for time delay and money delay to send the plans and et cetera off. So it's very interesting.
And I think on the gas station case, you know, the real issue for everybody is the use. And if the ZBA had gone through the DRI process, that might have been resolved. And by the time it got to the planning board, there, you know, it either wouldn't be an issue in the site plan, or there wouldn't have been a site plan. So
Right.
yeah, it can go either way.
Yeah, and like I said, you know, boards that look at it from a different thing. If you're looking at a special exception, they're guided by traffic impact to the neighborhood by specific things.
Right.
Variance, planning board looks at site plan things. So it's certainly feasible for both boards with an application in front of them to declare DRIs on using their own guidelines. It's certainly not out of the norm, and good practices for boards to keep up with. A little bit for almost like Susan's case is, should a neighboring communities wait to be notified by the subject municipality?
No.
Yeah. Yeah, no. You know what? Keep track of your neighbors, right? If you hear things that are going on, again, you can always reach out to your regional planning commissions, keep track of some of the agendas, you know, and yes, you know, word of mouth, you know, may be helpful, but, you know, it's good to know what's going on in your own neighborhood and next door.
I think one of the issues that was raised here was the board didn't consider DRI, didn't even do a review because a neighboring municipality had not asked them to. And that's, you know, it's not up to the neighbor to initiate, it's up to the board with the application to do the review.
Correct. Yeah. And so what is the role of the RPC in the DRI determination process? What exactly do you guys do?
Well, I think different RPCs have different processes internally that they follow. For us, we have a set of guidelines. We look at the factors in the statute. We look at the questions in our guidelines, and we comment, you know, put a memo together and submit comments to the board. Say if it's a transportation network issue, we might look at our corridor studies that we have may have done on that state highway, raise any concerns shown in those corridor studies, you know, things like that. Maybe encourage the board to seek independent, you know, expert analysis to help them make certain technical decisions, you know, those type of things.
Yeah, our process, I think Susan's right. I imagine they're a little different at each RPC, but ours is somewhat similar. So we take the applications as we receive them. We review them compared to our regional plans, and we consider sort of what the scale of that impact may be. And we issue written comments. Depending on sort of the amount of involvement we think we might have in it, we will attend hearings sometimes too throughout the process. But so that's sort of how we do it. It's an interesting piece to say that we only respond once a DRI has been determined, though. So that is a sort of piece of sort of who owns what responsibilities where. And it's our duty to respond and provide comments and help see where that may impact neighbors or in the bigger context. But we can only do that after the municipality has determined a development of regional impact. We're advisory to the municipalities, and so it takes that sort of engagement to pull us in there. So that's kind of our process.
Yeah, I think ours is very similar. You know, we also will wait to be asked, but you know, if you have questions about the process, we are more than happy to sort of talk through, here's how to declare, here's how to send the notices out. I think we might have one of the more formal policies because we actually have a regional impact committee that's a subcommittee of our commissioners. It's a 3-member committee, so 3 full members, but then we also normally have up to 3 alternates so that we can hopefully get, you know, 2 out of the 6 people who are designated to show up to meet quorum. And you know, basically our process is the same. We'll still do a staff memo, but then we're basically running it through that board of our commissioners for feedback on the memo, you know, other questions or considerations or things that they would like to see added or changed before we send it back around. And I think that has some benefits and some drawbacks. It's definitely more work on our end when we have to run through that full process. But I think having that, you know, board of commissioners, you know, providing feedback and chiming in on the process, it's almost like you're getting comments from a jury of your peers. Yeah, because a lot of them are, if they're not on their own land use boards in their own communities, they have a lot of the similar qualifications. So it's sort of a way for, you know, them to, I guess, temper some of what's coming from staff and make sure that we're also not giving the impression of, you know, critiquing people's processes or you know, that we're explaining to people with a variety of experience and skill levels and familiarity with state statute, with policies in other communities, you know, instead of, I guess, just relying on what seems most relevant to staff.
Yeah, great. Thank you. Someone does have their hand raised, and I just wanted to check in with that person if they're still here. If you want to throw a question in the chat, or just want to make sure that we see you, or if that was a mistake, or just let us know, or throw your question into the chat if you have one, or a comment. A little bit of what Kayla was kind of speaking about in one of their case studies is what is the difference in the notification process for RSA 12K and for DRI? RSA 12K being the telecommunications ordinance, RSA.
Yeah, so 12K, this is something anyone who's ever sat in the exact position we have before of a DRI that was a cell tower, which seems to be more and more popular as we're trying to get better and better communication infrastructure around. We ran into this place where 12K requires very specific regional notification in a very, very broad sense for the visual impact. And so it's interesting to see there that there's separate notification processes, right? So in 12K, you are required for notification to reach out to a 20-mile radius of communities that might be impacted, which is a very, very large area. And what's interesting in our case study with the cell tower was that who was notified through 12K and who was notified through the DRI were different because of the topography. So because of the location of it, the 12K notification hit many communities who frankly just could not possibly see this, right? Because of just the mountains and where we are, the topography makes it such that the view sheds don't have that sort of distance to them. So a lot of municipalities were notified through 12K. The DRI process was a narrower one where it actually just honed in on realizing it was somewhat of an isolated visual impact coming mostly from the tops of the mountains and less from the areas that were in municipal boundaries. So I think the take-home point here is there are different processes, the notification can be different, and you can critically look at and make your decisions about who you notify as a DRI, whereas it might be mandated in other spaces. So it's important. This kind of goes to a piece James brought up too about development applications that abut a municipal boundary. It's important to double check and just make sure you know all of the notification requirements that might come with a particular type of application because they can vary.
Right. Yeah, good point. Good point. And for that, James talked about it a little bit. Maybe James, if you want to just take 2 seconds to just kind of, if people aren't familiar with 674-53, explain that notification process and what's the difference. We've talked about it a little bit, but I know you've encountered it, and I think it's a great topic.
Yeah, so again, it's, separate RSA, separate process, and that one is dealing a lot more with if this, then here's how you notice, or here's what benefit communities get. So, in our region, we've got some fairly straight line municipalities that don't correspond to your property, your parcel boundaries, or if we've got commercial corridors that run from Dover to Madbury to Durham, you get a lot of those things where part of the parcel is in a different community. The property line is also the municipal boundary line. So some of that deals with, all right, if the property spans the boundary, who reviews it for what, and whose regulations does it have to follow in what ways? If the property line overlaps with the municipal boundary, I think the governing body of that municipality is entitled to notice as an abutter just right off the bat. So for that, you don't even need to wait for development of regional impact. That town's select board or city council or town administrator should be on the abutters list that comes in with your application. For the example that I gave where the only road access is from an adjoining municipality, even if the property is, several properties in. I've had one that was as far as like a quarter of a mile down the road, but it all came through the adjoining municipality. So their planning board was entitled to review the application and comment only on access to the site and the impact to their road. For something like that, while they may have jurisdiction to hear the application themselves, that is thematically limited, and they can't speak to utilities or solid waste disposal or pollution or noise or things like that under their own proceedings because they're limited by statute to just here's our road access. So that might be one where you consider, all right, they have status to hear this, but We want to declare regional impact because they are likely to be impacted in ways that go beyond what they already have the authority under 674-53 to discuss.
Yeah, great. Great, thank you for that. Thank you for that explanation and the clarification. So we obviously ran over. We appreciate everyone hanging with us. Great topic, great discussion and examples. I just want to give anyone one last chance. If anybody, I see someone had their hand raised, but then I'm not sure if we addressed their question. Anything else? So we'll kind of just finish up here with some additional resources. The guides that Susan and Kayla talked about, they will be available next week on the website when this is posted. Just to a few other planning commissions that offer DRI guidelines and reference material. So know your RPC, know which region, reach out to help, reach out for help with their guidelines. And again, I just kind of want to go through, just some best practices for us and for me and the panel to go through is, is kind of a common theme is be a good neighbor. Susan's, example of that the community didn't have to reach out to the communities in Maine, but they did. Be a good neighbor, be proactive, cooperative, and a little bit of a typo there, but avoid confrontation as best you can as a community. Those sometimes confrontational topics can last a long time. So just again, be cooperative and collaborative as well. I know Kayla spoke about that. And we spoke about being proactive for your surrounding communities and their meetings. So if you want an opportunity to be nosy, there's your chance to do it, to see what's going on next door and see if there's anything that you could be concerned about, at least just to attend the meeting to learn more. And again, Susan spoke about it and kind of some of the questions along those themes of when do we declare and what makes it a DRI, kind of along the lines of when in doubt, don't. But the RSA declares you that if there's doubt concerning a regional impact, whether or not it's going to be a regional impact, then they shall declare. So when you see those words "shall," if there's questions of whether or not should we or shouldn't we, the RSA is telling you that you should definitely declare a DRI. So with that, going through some of those best practices, I'll open up to the panel one more time and for some final thoughts.
I guess my final thought would be that, this is not a process that encourages disputes among municipalities. Exactly the opposite. Just share concerns, share interests and considerations in making your decisions. And that's what it's all about. Aspirational, good regional planning.
Yeah, absolutely. Thank you.
I suppose my closing words will be reach out to your regional planning commission staff, right? You guys are seeing Susan, James, and I here, but I think if there's one piece that's come through between the lines to me, it's we don't just respond when the notification has happened. We can help you see how your board should make those decisions, how to get that into your checklist, what are some of the best procedures you guys can be doing in your communities and how to get ahead of these things. Definitely see us as a resource early on. Don't wait to notice to reach out to us because we can help you sort of think through what you're doing too.
Absolutely. Great points, Kayla. Great points.
And I think where I normally land on is, in this process, the planning commissions are here to be advisory. We're here to give you information you might not have, sort of help you answer process questions. So, one, I'm definitely not looking to elbow my way in and start critiquing your land use decisions. But I'm here to help. And I think to that point, communication and particularly fast communication. I will never tell you not to send the legal notice via certified mail the way you were supposed to, but I would love it if you emailed me the next day instead of waiting until I get that notice in the mail to start my work.
Yeah, Absolutely. And you know, the collaborative and the awareness and all of these phrases and terms that we're using and you know why the DRI is underneath, you know, the RPC, the RSAs is because the RPCs are there to work for you and with you. And maybe it's a DRI application, but if you've got a complicated site plan in front of you, reach out to your RPC. They can help you look for things that you should maybe take care of in a condition of approval, or just be that advisory role for these boards who have, you know, these big applications with a lot of moving parts. You know, the RPC is there to help, as we are here at OPD as well, to help you kind of weed through some of these applications. It may not be a DRI, but doesn't mean that the RPC still won't offer their services. So good to reach out to them. So again, thank you very much. Put our contact information here. We thank you for attending and staying with us through the duration for our planned webinar. If you think of it, there is a survey that you could take for this webinar or other webinars that you've attended. My contact information is there. Susan's, Kayla's, James, you can be found at Stratford Regional Planning Commission. So again, make sure you take the survey. Thank you for joining us. And also we have our April webinar, so pencil in your calendar. For our April plan webinar will be held on the 21st from noon to 1 p.m. And it's going to be discussing electronic vehicles. So keep that in your calendar. Notification will be coming out soon. And again, thank you very much for attending and your patience. And again, thank you very much to the panel. You guys are a wonderful resource, great presentations and information, and it's much appreciated.
Thanks.
Thank you.